right, good morning, ladies and gentlemen. My name is Judge Lal, and let us begin with our state all-purpose calendar. We see a couple of folks here. Okay. Rose, Mr. Murphy. All right, we have folks in courtroom too. Good morning. Good. All right. As I was saying, my name is Judge Lal, and this is going to be the Fulton County State Court misdemeanor calendar. It's called the all-purpose calendar. These are misdemeanor criminal cases in which individuals had already been formally accused. Bonds have been set. In most cases, attorneys have also been assigned to them. Today, we are going to get a status of those cases as to whether the individuals would like to consider a plea offer from the prosecution and enter into a plea hearing in exchange for a recommended sentence, or whether they would like to plead not guilty and have the case further noticed for trial. Some other matters we would be addressing are probation revocation, any bench warrant matters, as well as bond modifications. If you are a defendant charged with a misdemeanor offense or offenses, please do remember that you have a right to remain silent. Anything you choose to say during this virtual court proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Okay, Ms. Vigiletti, good morning. Are you by yourself, or is Mr. McLean with you, or somebody else?
I am by myself, Judge. Mr. McLean is on his way. I'm sure you saw my announcements. I spoke to maybe 3 of my 17 clients yesterday, and
Okay.
so I would appreciate some time to talk to these folks.
Okay, let's see now. Are all 3 of the ones you've spoken with in the courtroom with you today?
I have one person here today. Willie Moore is a probation case.
Okay, so you still need to speak with others.
Yes.
And let me see. Ms. McLeod, who is your client?
Curtis Gibbs, Your Honor. Good morning.
Good morning. And is this on the all-purpose calendar?
Yes, Your Honor, an add-on.
Is that person in courtroom 2 presently?
Yes, he is, Your Honor.
All right, may I address that first? Mr. Murphy, who is your client?
Mr. Chestang, he's position 1.
He's upstairs, Your Honor.
Okay, we will address him next, and then after that, we'll get to Ms. Vigiletti's cases. All right.
I still need to speak with Mr. Gibbs, Your Honor, to
Oh, you
discuss
do?
the offer with him, yes.
Okay,
I don't have a phone.
Deputy, can she call the jail?
I don't have the phones are still down.
Oh, that's right. You
And I
know,
don't
I
have
don't know
a
why I keep forgetting that. We'll need to put you in a breakout room.
Thanks, Your Honor.
Let me see if I can impose on Miss Vigiletti. Miss Vigiletti,
Yes, Judge.
would you happen to, oh, you need your laptop? I was going to ask if we could use your laptop to put courtroom 2 in a breakout.
Oh.
You know what? That's what we're going to have to do. Let me see. Miss Deputy Morris, could you put Miss McLeod's client in courtroom 2? And we will put courtroom 2 in a breakout with Miss McLeod. And then Miss Vigiletti, you will continue with your interviews.
You want to put Miss McLeod's client where?
Yeah, that's unless we have a laptop that you could.
Yeah. Why don't you just use mine? Hold on, let me just.
Okay, good. I'm glad Miss Vigiletti offered that. Okay. All right, we'll let courtroom 2 organize that. Miss McLeod, you're going to be in a breakout with your client using Miss Vigiletti's laptop.
Thank you, Your Honor. I will be able to talk to him about the state's offer and see what he
My
wants.
next life, I'm going to be a party planner because clearly this is a lot of organizations. Okay, and let me see. So that's going to take care of Miss Vigiletti. Is going to talk to her other clients. Mr. Murphy, your client is the gentleman.
Mr. Chestang.
All right.
Chastain is upstairs. We have to wait for an officer to get up there, Your Honor.
All right, Mr. Murphy, please hold until we get Mr. Chestang on one of
Okay.
the jail court iPhone or one of the other locations.
Your Honor, Mike McLean is here now. I don't have any ready,
Mr. McLean, yes, good morning, sir. Why don't you settle in and then we will take up whichever case you're ready with.
I understand so far, Your Honor, that I have one negotiated plea on the calendar, and that's Mr. Sanders. That's per Mr. Haddad, that he's ready, and I'll double check on that.
Okay, thank you. Ms. Vigiletti, you'll have to place Ms. McLeod's client on your laptop. Okay. All right. Let me see who is hosting this morning. Ms. Champion?
Yes, ma'am, I'm about to put them in a breakout.
Okay, Ms. McLeod and Ms. Vigiletti's laptop will be in a breakout.
Yes, ma'am.
All right. Deputy, if you could please make a note of the message in front of the screen. Okay. Oconee County Jail. Who do we have, please?
Say your name, Mr. Reginald Walls.
Okay. Is Mr. McLean or Ms. Vigiletti representing Reginald Waltz? Might be on my updated. Give me a moment, Mr. Waltz. I'm waiting for one of the public defense attorneys to come back on screen. Mr. Michael McLean?
Your Honor.
Judge, if I may, I do have some information as it relates to Mr. Wall's case.
Oh, yes, I understand. I just need to know who his defense counsel is.
Mr. If it's Reginald Walls, that's me, Your Honor.
Okay, this is just briefly for announcement purposes. We have Reginald Walls appearing from Oconee County Jail, case number 24 CR 380B, accused of battery, family violence in Fulton County, Georgia, stemming from a November 23rd, 2023 incident. Mr. Walls, you have a right to remain silent, and your attorney, if anything you choose to say during this proceeding, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Go ahead, Mr. Rhodes.
Yes, it looks like that we are going to request transfer to the DA's office on this case. The defendant, Mr. Walls, was convicted on a family violence battery under case number 11 CR 374956 previously. So
Has it been approved by the DA's office for a transfer?
let me see. I'm not showing that it has been approved as of yet, but we've made that request, Your Honor, based on the subsequent conviction by matter of law.
Okay, all right. So, Mr. McLean, at the present time, it appears there's no plea offer, but a pending transfer to the DA's Superior Court as a felony matter. How would you like to proceed?
Your Honor, I need the assistance of the court to make sure of what his bond situation is. I have been unable, because of our computer outage, to satisfy myself that I know what his bond is. Whether or not this is holding him in, and if so, I would like to make a bond argument if it is holding him in.
Mr. Rhodes, do you have a bond order on your system as we can see, he is currently detained in another facility.
One moment, Your Honor, I'm trying to pull his information up now.
Or Ms. Champion or Ms. Thomas? Do you have limited access? Or sorry, not Ms. Thomas, Ms. Melissa Grace.
I'm sorry, Judge, what was the question?
This is position 9 on the add-on SAP calendar, and I'm trying to figure out Mr. Reginald Walls' current bond situation with Fulton County.
I'm done. Yes, Judge, it's a $3,000 good bond.
All right, that's what we have, Mr. McLean.
How many thousands?
3.
3. Your Honor, the main bond argument I could make for him, I told him when I met him in visitation here at Rice Street, in preparation for the last calendar, I think that would have been Tuesday. I think it was probably Monday when I saw him, if not last week. I think it was Monday. So, Your Honor, the main argument I would make for him is that the prior that the prosecuting office has mentioned has an 11 CR number on it. I have not yet been able to confirm. I've got my fingers crossed and I'm hopeful that perhaps that was not a BFV. I'm hopeful that that was reduced as it pled or was otherwise found guilty, if indeed that is a conviction. I've not been able to confirm it. Because of that uncertainty, Your Honor, I do know that he is working.
The Solicitor General's office seems to be fairly confident that it was a battery family violence conviction under case number 11 CR 374956. Mr. Rhodes, is there any question as to the nature of his conviction?
There is no question, and to be candid with the court, these are notes that were passed along to me from Deputy Shelley Falk. She did research this case, and she indicated that this was in fact a family violence battery conviction from 2011. So those are the notes that I have. Obviously, we are all compromised. I do think that the bond that he has is reasonable, considering the fact that it is a $3,000 good bond, and there is indication that he does have past. He does have a past. So I believe that the notes that I received from Deputy Falk are accurate.
All right, Mr. McLean, that's the current situation. So, what's the request?
Right, my main argument, Your Honor, is that while the state does sincerely believe that 3,000 is a reasonable bond, we also believe that a signature bond would be reasonable, or $1,000 bond surety would also be reasonable in a situation like this, because 2011 was a long time ago, and the date of offense on the 11 CR could be even, it could be 2010 or 2009. We would just ask the court to consider that passage of time as a major factor. And I'm not aware of any other trouble he's been in, but that's because none of us have access worth a darn.
Understood.
Thank you.
Understood. Under the circumstances, the bond amount is going to remain the same. And Mr. McLean, do you want to have this case arraigned or wait until Mr. Waltz is transferred to Fulton County?
It can wait, Your Honor. If the DA's office decides not to take it, we'll see him soon.
All right. This case is going to be reset to the SAP calendar 2 weeks out. And that's going to be the 29th of February.
Your Honor,
And this would be pending the transfer to the DA's office. At the present stage, I don't know if it's been confirmed that the case has been accepted. And if it's been accepted, then the transfer will be executed. And once Mr. Waltz is in Fulton County, he would have to address the case in the Superior Court of that matter. Mr. Waltz, did you have any questions of your attorney?
No, ma'am. It'll be on the 29th at what time?
9 a.m. Same time, same way, unless you are here in Fulton County.
Okay,
Your Honor,
no problem.
All right.
Not just for the fun of it, but because there are no clients behind me on these pews that I represent, and I don't see on ACDC screen anybody that there is Miss Riles that I have, but I wondered if it would be convenient for us to have a short breakout. If I put my cell phone on Zoom, could I have a breakout with the Oconee County Jail, Mr. Walls?
Okay, I think Oconee County Jail has just signed out.
Your Honor, I have Ms. Rouse here.
Okay. Mr. McLean, Oconee County Jail has already left.
Okay, I'll get hold of them by phone, Your Honor.
All right.
Mr. McLean, it appears that there may be a number assigned for the subsequent battery, family violence, subsequent conviction. I'll check into this, but what I have is 23 SC 188324.
That seems to be a case that's already indicted rather than recently accepted.
As a CP number. Okay, that might be a previous.
Okay, thank you.
Thank
All
you.
right, let me just get back to other matters for a moment. Yes, Mr. Murphy, did you have a question?
Judge, I had a brief announcement on Chestang.
Yes, sir.
The state has given me an offer. I'd like 2 weeks to discuss it with him. I have a trial next Thursday with Judge Besson, and I need to speak to my client's felony attorney. And I have spoken to my client's sister, so my clients are well aware of this development.
All right, position number 1 on the all-purpose calendar, Javaris Chestang, is reset to February 29th, 2024.
Thank you, Judge, and I'll see you back at 11. I have 3 cases on.
All right, sir, thank you very much. See you on at 11 o'clock.
Thank you, Judge.
All right, Ms. McLeod, are you ready to address your case?
Yes, Your Honor, this will be a negotiated plea.
All right, and yes, Mr. McLean?
While y'all are doing that, would it be possible for ACDC to call 770-842-5471 so I can ask Ms. Riles a question?
You probably need to repeat that
Sorry to be so
number.
rude today.
Deputy Milton? Okay, I think she's going to get a piece of paper to write down the number. It would be best, Mr. McLean, if you put that number in the chat.
Okay.
Okay.
Can you put a number?
Okay. And the gentleman seated next to Mr. McLean, who is that, please?
779.
This is Cartel Gibbs.
Repeat the last name.
Gibbs.
That is my client, Your Honor.
Repeat the last name. I'm just trying to find his position on the calendars.
5471. That might be them calling there.
Miss,
He's on the add-on calendar, Your Honor.
he's on the add-on, okay. Repeat the last name, please.
Position 3 and position 3 on the add-on calendar.
Thank you, Deputy. All right, got it. I'm sorry, I'm quite a few calendars to negotiate today. Okay. This is State versus Cortez Gibbs, who's seated in courtroom 2. Case number 23 CR 002-461H. Mr. Gibbs has been accused of battery against a female who is pregnant and simple battery family violence from February 2nd, 2023. Ms. Gibbs, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Maureen McLeod. This is going to be a negotiated plea hearing. May I place you under oath?
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Okay, Mr. Rhodes, yes, sir. Do you have a plea recommendation for Mr. Gibbs?
Your Honor, that's going to be me.
Oh, I'm sorry, Ms. Kim. Okay, please proceed.
Thank you, Your Honor. The state's recommendation would be 12 months of probation, 12 months, serve 45 days, take a family violence intervention program, and no contact with Joanna Mobley. That's Jawanna. Mobley is Mobley. And I believe this is a global resolution with position 3 as well, 23 CR 002461H, where the state's recommendation would be 12 months of probation to run concurrent.
Okay. Ms. McLeod?
Yes, Your Honor, that is my understanding. I just didn't hear credit for time served, which I just presumed this was a credit for time served, 45 days, correct, Ms. Kim?
Yes.
Okay.
And Your Honor, we would ask the sound for the victim. I believe she is on Zoom today. And the state would also ask the defense to stipulate to ID, venue, and factual basis for purposes of this plea.
All right. You said it was Mobley, right? Mobley? I don't, unless there's an iPhone here, but I don't.
Yes, I'm Miss Mobley.
All right. Okay. That's Miss Mobley. All right. Miss Mobley, my name is Judge Law. Did you have any comment about the sentence that's being recommended for Mr. Gibbs?
Yes, I do want contact with him because we have a 10-month-old son that have sickle cells. So I do need to be in contact with him.
Does the state have any objection to no violent contact?
No, Your Honor, and just to correct myself, I believe Miss Gibbs was arrested January 19th, so I believe that's actually 28 days of credit time served.
So he's going to get credit for time served.
Yes, ma'am.
Okay, just want to make sure.
So that would be to serve 56 days, credit for time served 56 days. Would that be correct, Ms. Kim? Am I correct? Is my math right? Or am I off the ball? 28 days, right?
Yes, ma'am.
So Ms. McLeod, you're the math whiz. Is it 56
I
days?
am not the man who I think it's something like that. This was for Tuesday, it would have been 45 days. So he since served 2 extra days. So that'd be 47. Wow.
It is 56 days, Your Honor.
Thank you. Okay.
That's why I went to law school.
He's been in custody for 28 days and twice of that is 56 days. Okay. All right. So again, the state has no objection to no contact. Ms. McLeod, do you stipulate to the factual basis, venue and ID?
I do, Your Honor, and I would just like to say something also when the court is ready.
Go ahead.
Yes, Your Honor, my client has been locked up for about almost 2 months, something like that, but a considerable amount of time. He has lost his job since then. So I would ask the court to consider waiving the first 3 months of probation at least, so he can take this course.
I will waive up to February, March, and April, through the end of April.
Yes, Your Honor, and also if his probation could become non-reporting once he's completed the course.
Miss Tyson, I think this is the one where he's got a significant history. Ms. Tyson, could you give me a history on Cortez Gibbs? Position 3 on the add-on calendar.
Okay.
Just go ahead and let me know. I'm
Okay, yeah. He has 7 cycles beginning in 2007. So let's see, within the last 10 years, he does have a felony conviction out of Fulton County for aggravated assault. That's outside of the 10-year period. That's from 2010. Let's see, an armed robbery, burglary, and possession of a firearm or knife during the commission of.
Thank you. Yeah. No, that's a no to termination or non-reporting.
Thank you, Your Honor.
Okay. So would he like to still proceed with the plea?
Yes, Your Honor.
Okay. Mr. Gibbs, have you consumed any medicine or alcohol?
Ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney services?
Yes, ma'am.
Is anyone forcing you or inducing you to plead guilty today?
No, ma'am.
Are you doing so freely, willingly, and voluntarily?
Yes, Your Honor.
If you decide to enter a guilty plea, this would be a battery family violence conviction on your record. Do you understand that?
Yes, ma'am.
And any subsequent arrest for a same or similar offense will automatically be a felony charge. Are you aware of that?
Yes, ma'am.
And Mr. Gibbs, do you understand that you would have to give up your constitutional right to go back to court and have a trial in front of a judge or a jury? You will not be able to confront your accuser. You will not be able to present any defenses or arguments to the judge or jury. You will not be able to challenge the evidence that's brought against you. And you will not be able to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead? To battery against a female who is pregnant,
Oh, I guess Gibbs.
I can't hear you.
I say Gibbs.
How do you plead to simple battery, family violence?
Gibbs.
Your sentence on count 1 is going to be 12 months to serve 56 days, credit for time served 28 days. The balance will be probated. If you have no other holes at the jail, you will report to probation office next Thursday at 132 Mitchell Street in downtown Atlanta, and you must report before 3 p.m. While you're on probation, you must enroll in a domestic violence intervention program. You must enroll in that program within 60 days of being released. You are to have no violent contact with Johannan Mobley. You're not to consume any illegal drugs, no alcohol, and you cannot own or possess or have a firearm anywhere near you, on you, or in the same home as you. Do you understand?
Yes, ma'am.
Your probation fees shall be waived from the time you report up through and until the end of April 2024. You will, after that, continue to report to probation until your time is completed.
Yes, ma'am.
Thank you. That concludes this case.
Thank you, Your Honor.
Ms. McLeod, do you have any other matters, including the 11 a.m. calendars?
Yes, Your Honor. I have another matter on the competency calendar.
Okay, I will see you then. Otherwise, you're free to go.
Thank you, Your Honor.
Thank you, ma'am. All right. Jail court iPhone, who do we have, please?
We have position number 14 and position number 6 on the probation calendar. Mr. Smith.
6 and 14 on the probation calendar. Both our PDs are still talking. Ms. McLeod, did you have another case?
On the probation calendar as well, Your Honor.
Okay. Let's see, position 6 is Durante Smith. Is that your client?
That is my client, Your Honor.
And position 14, that is, I don't have a position 14 on probation unless I didn't print it.
No, he's not on the probation calendar 14, it's just 14 on the regular calendar.
On the regular calendar, okay. Okay. All right. Ms. McLeod, your client is on jail court iPhone. This is Durante Smith. Durante Smith has 2 separate cases. Mr. Smith, my name is Judge Lal. I'd like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Maureen McLeod. Do you see Ms. McLeod on your screen?
Yes.
Yeah. Do you see Ms. Oh, yeah, as soon as we got. Do you see your attorney on the screen? Mr. Smith? You need to say yes.
ma'am.
Okay, good. Thank you. All right, let's begin with the SAP calendar first, position number 14. This is a new case for Mr. Durante Smith, 22 CR 005853E, in which he has been accused of battery family violence from a June 5th, 2022 incident. All right. And let's address that one first. Ms. McLeod, how are we proceeding in that case?
Well, he has not been arraigned yet, Your Honor, and I have not received an offer from the state.
Okay. So you've not had a chance to speak with him.
No.
Mr. Rhodes, is there an offer that was recommended?
Yes, Your Honor, there is an offer. I could give it to Attorney McLeod now in the breakout room, or if
you can put it in the chat to Ms.
You can put it
McLeod.
in the chat to me. Mhm.
All right.
absolutely, I'll do that right now, Ms. McLeod.
Thank you. Shortly after you receive that, Ms. McLeod, I'll put you in a breakout room with the jail court iPhone. Would
Thank
you
you,
like
Ma'am.
to then address the probation revocation matter? I'll have Officer Allison just allocute what is the state's recommendation on the revocation. Officer Allison, good morning.
Good morning.
All right, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Durante Smith has a probation revocation matter as well in 22 CR 000090E. And Officer Allison, what is the recommendation for Mr. Smith?
Would you like me to just state the recommendation or read out the?
Well, what was he convicted of?
He was convicted of DUI, less safe, hit and run, and following too closely.
And following too closely. And what were the alleged violations?
He failed to pay court fines and surcharges in a total of $2,071, probation supervision fees in a total of $160, victim crime funds in a total of $36, failed to report as directed on October 9th, 2023 and October 16th, 2023, did not complete drug and alcohol evaluation, failed to provide proper samples for court-ordered drug and alcohol testing, failed to complete 80 hours of community service, did not complete risk reduction course, did not complete victim impact panel, and failed to appear for a court hearing on November 15, 2023. He has 59 days remaining on this case. Probation is recommended to revoke the balance.
Okay. All right, Ms. McLeod, that is the recommendation for the probation revocation to revoke the remainder of the 59 days. And he's been in custody, I believe, since January 19th, 2024. So
Yeah.
less than 30 days. So have you received the offer from Mr. Rhodes?
I have, Your Honor.
All right. I'm Miss Champion. If you could place Miss McLeod in a breakout room and jail court iPhone, you will see a message on your screen to join a breakout so that Ms. McLeod may speak to her client.
Okay.
All right.
Go ahead and pop one.
Your Honor, good morning. This is Milton at ACDC.
Good morning.
I have Ms. Zakia Johnson, position 7 on the SAP calendar.
All right. This is an announcement to all the individuals who are right now seated at ACDC with Deputy Milton. My name is Judge Law, and we're going to be addressing all your cases on this SAP calendar. Please remember that you have a right to remain silent. Anything you say in open court, this virtual recorded proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Position 7. Position 7 on our SAP calendar. Zakia Johnson. And who represents her? Miss Abden? Okay, Miss Abden, you're on mute. I'm sorry.
Good morning, Judge.
Good morning.
I do represent Ms. Johnson. She's position 7. We're asking for a reset for next Tuesday. I do need to speak with the felony attorney. Haven't had a chance to do that.
Right. That would be February 20th.
Yes.
All right. Ms. Johnson, your attorney is Miss Rachel Abden. Do you see her on the screen?
Yes.
All right. She is requesting that the case be addressed next Tuesday, so she will have an opportunity to consult with the attorney in your other case. All right.
Okay.
So the case is now, your current misdemeanor case is reset to February 20th at 9 a.m.
Okay. Thank you.
And Ms. Johnson, I'm going to come see you later today so we can talk a little bit more about your the offer.
Okay. Thank you.
Thank you.
Deputy Milton, is there another case I can address? There are two individuals.
The Ms. McNeil, position 4 on the probation calendar. The others is on probation.
All right.
Position 5 is Ms. Riles. She is talking to Mr. McLean, and Ms. Ware, who is position 7. These 3 ladies are on the probation calendar.
All right. Ms. Vigilante, do you represent any of them at ACDC?
No, Judge, these are all Mr. McLean's clients. I did also just want to make an announcement very quickly because DeMontre Kendall, who's position 10 on the probation calendar here, is represented by Ms. McLeod, and I just wanted to announce it as soon as possible in the hopes that we could maybe get her back if she's already left for the day.
What was the name of the individual?
Demontre Kendall, it's position 10 on the probation calendar.
I see. Okay,
McNeil. I'm sorry.
all right. All right,
Position 4, Your Honor.
okay.
I'm not, if the name were given too, that would be helpful.
Deputy Milton, position 4 on the probation matter. This is Kimberly McNeil.
Correct.
Is that your client, Mr. McLean?
Yes, Your Honor. Although in the McNeil case, we've not had a chance to converse, nonetheless, if I remember correctly, and I'm flipping my papers quickly, this is going to be a recommendation from the probation department of time served and close the case.
Well, I'll be glad to let Officer Allison allocute her recommendation, and if you need to speak to Ms. McNeil, we can place you in a breakout.
I have a feeling we won't really need to speak. I think this is going to be satisfactory.
Funny, I have the same feeling too, but I'll let Officer Allison mention it.
Thank you.
This is Kimberly McNeil, case number 19 CR 006840F. Ms. McNeil was convicted of criminal trespass. Ms. McNeil, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. Excuse me. Officer Allison, what's the state's position?
Ms. McNeil failed to pay probation supervision fees in a total of $320, victim crime funds in a total of $72, failed to report as directed on February 23rd, 2023, March 9th, 2023, March 16th, 2023, April 28th, 2023, and May 9th, 2023, failed to complete 20 hours of community service. She has 78 days remaining on this case. Probation is recommended for time served, case closed.
Mr. McLean, what's the defense position?
As long as Ms. McNeil understands that it will be marked down as an unsuccessful finish to the probation, unless she wants to argue about that particular thing, I'll be glad to advise her. But I think that probably this is sounds like a course that she would accept. Is that correct, Ms. McNeil?
Yes.
Okay, I think that's it. Thank you.
This will be recorded as a probation violation. The court will accept the state's recommendation and commute it to time served. She's been in custody since January 23rd, 2024, and the case is closed. Thank you.
Thank you.
Thank you.
Next, we have position 5, Ms. Royals.
All right, this is State versus Veronica Riles, R-Y-A-L-S. Case number 23 CR 1398D. Ms. Riles was convicted of criminal trespass causing damage to property and/or criminal trespass, and she has been in custody since January 19th, 2024. Ms. Riles, you've been advised of your right to remain silent, and your attorney is Mr. McLean. What's the state's recommendation?
Ms. Riles failed to pay probation supervision fees in a total of $240, victim crime funds in a total of $54, did not complete mental health evaluation, failed to comply with modified order from September 26, 2023, and failed to appear to a revocational hearing on October 24th, 2023. She has 166 days remaining on this case. Probation is recommended to revoke the balance.
Right. January 19th, so she's been in custody for about 25 days, give or take. And the state is asking that we revoke her 156 days, give her credit for the 25 days that she's been in custody. And Mr. McLean, what would you like to do?
Well, she has 3 children that are, I believe the one that is not in school is approximately 3. There's one child in pre-K who's 5. There's a child who's in 1st or 2nd grade, I believe 2nd grade, who's 7. Her mother-in-law has moved into her house for the last 26 days to take care of the kids and make sure that they get to school on time and eat and sleep well. Her entire income is a disability check, Your Honor. It's been 26 days on that in her jail stay, and she's going to lose that check rather quickly. This is an emergency situation for the family. It is unfortunate that she did not complete everything as she had promised. She tells me that during a COVID period that she did go to 132 Mitchell, second floor. She described it to me, and that her instructions, if that was the same case, I hope it was, that her instructions were basically to go up there, sign in, and then leave because the virus was on. I've discussed with her where to get a mental health evaluation, how to do it, and I believe she understands. She does not have for me the phone number right now to confirm with Miss Miriam Bird, her mother-in-law, the family situation. I suggested to her that waiting till Tuesday would enable me to prove to the court things that I'm simply saying to the court. And I would prefer to prove them. However, it does sound like a really bad situation in that the loss of that income would be terrible. If I may then switch, Your Honor, basically to an argument of perspective. This is a criminal trespass case. A family is in need. Society would be better served if she were home. And she apologized. I told her, apologies aren't necessary. What we need is your performance. But if the court could accept her apology and allow her another chance, we realize that would be probably not just a second chance, but it sounds like maybe a third. But this is a mercy situation. She is in dire need, and our kids are too.
Ms. Tyson,
Yes, Your Honor.
this is Veronica Riles on our probation revocation calendar. Have there been any arrests in 2023 except for in 2023?
2023.
There may be one for a probation matter, but I don't know if there's anything else.
Let's see. She has one from, let's see, September 24th, 2023, willful obstruction, simple assault, theft by shoplifting, 2 counts of willful obstruction. She had another one September 12th of 2023 in DeKalb County for theft by shoplifting and willful obstruction, a probation violation in June. Let's see, PI in DeKalb County, May of 2023. 2 counts of criminal trespass, March of 2023. Another criminal trespass in March of 2023. Theft by shoplifting, giving false name, February of 2023.
That's good.
Yes, that's
Thank
it.
you. Mr. McLean, I do understand your argument, but it appears that Ms. Riles was busy not reporting to probation because of other in other criminal matters. I'm going to revoke her balance. I'm going to give her credit for 25 days. And she would have to serve out the rest of the time at the Fulton County Jail until she's done with this case, after which then the matter will be closed out. Thank you.
Next, we have position 7, Ms. Ware.
And Ms. McLeod, we're going to be addressing your client's cases very shortly. By the way, you have another probation matter, Demontre Kendall.
Yes, Your Honor.
Okay, so I just wanted to be sure you knew that. Position number 7 is Charlesta Ware. Case number 20 CR 003-839J. Ms. Ware, you've been advised of your right to remain silent. Your attorney is Mr. Michael McLean, and this is a probation revocation matter. Officer Allison?
Ms. Ware failed to pay probation supervision fees in a total of $240, victim crime funds in a total of $54, failed to report as directed on September 12th, 2023, September 18th, 2023, September 25th, 2023, October 2nd, 2023, and October 16th, 2023. Failed to complete anger management. She has 253 days remaining on this case. Probation is recommended to continue on probation and enroll in anger management within 30 days.
Mr. McLean?
It would be my notion that she probably agrees with that recommendation and would like the chance to get out there and do that class.
All right. Ms. Ware, you understand that if I accept the state's recommendation, you're required to report to probation next week. And within 30 days, you must enroll in the anger management classes and prove to your probation officer that you are enrolled and attending those classes. If you fail to do so, another probation warrant will be issued against you. And the next time you may have to finish out the rest of the time in jail. Would you like to accept the officer's recommendation, or would you like to finish out the rest of the time in jail?
I would like to accept the recommendation, officer's recommendation.
All right. I will give you credit for the time that you've been in custody since January 22nd, 2024. You will continue on probation. You will report to probation on Tuesday. That would be before 3 p.m. at 132 Mitchell Street in downtown Atlanta. If I'm not mistaken, I think Monday's a holiday, correct?
Yes.
Okay. So it'll be next Tuesday. Do you understand, Ms. Ware?
Yes.
And after you report, you must enroll. I'm sorry, Officer Allison?
Sorry, we are open on Monday though, even though it is a holiday.
You are? The courts are closed.
Yeah, we're open though.
Okay, in that case, Ms. Ware, you report to the probation office on Monday before 3 p.m. Understood?
Okay, yes, ma'am.
And within 30 days from today, you must enroll in the anger management program. If you don't know where to enroll, you have to ask your probation officer for recommended schools. Do you understand?
Yes, ma'am.
All right, thank you very much.
Thank you.
Thank you.
ACDC?
Miss Royal says she has a March 5th court date and for DeKalb County.
They will check and see that she is detained in Fulton County, and that case will probably be reset.
Okay, thank you.
Or she would need to contact her defense attorney if she knows their name and number.
Ms. Mills.
Okay.
My felony is inside.
Okay, that's it for us. I'll be listening out for the compensate if you need those females.
Deputy Milton, thank you so much. Appreciate it. Thank you. Ms. McLeod, is your client ready? Durante Smith?
Yes, Your Honor.
All right, what would you like to address first?
We can address the probation first, Your Honor.
Okay. Durante Smith, probation matter is position 6. And this is 22 CR 90E. Officer Allison has already allocated the recommendation to revoke the 159 days remaining on his sentence.
It's just 59 days.
Oh, sorry, 59 days. Yeah, you're correct. 59 days. Ms. McLeod?
We're okay with the recommendation, Your Honor. The other recommendation for his other case, which he's inclined to accept, is 25 days credit for time served, which would be 50 days. And we were wondering if probation would consider just letting him have the time served so that he could get out today.
He's not done anything on his DUI conviction. Even if the state recommends it, I'm not going to accept it. Ms. McLeod? But the only thing I can give him is credit for the time that he's already been in custody.
I understand, Your Honor.
All right. On the probation, go ahead.
But it was 59 days.
It's 59 days, 5-9. He's been in custody since January 19th. So it'll be about, what, 25, 26 days? He has about 9 more days to go. Yes, no?
Well, he's going to accept the probation recommendation. I don't think he really has much choice where that is concerned.
Oh, no, I mean, if he wants to fight it, that's fine.
No, he
I-
doesn't want to fight it.
I have several options. I can not give him credit for time served and make him serve another 59 days. I can give him credit for time served and he can serve the remaining 9 days, or he can challenge
He's
this.
not going to fight it, Your Honor. I
Okay.
was just saying because the other recommendation was 25 days. I just wanted the court to have that information.
I'm not considering the other case at all. That's something y'all can do the math on. My concern is that according to probation, this man has not done anything for the conviction for DUI. Nothing.
He's going to accept the recommendation on that,
All
Your
right.
Honor.
This is, his probation is revoked. This is going to be marked as a probation violation. He has 59 more days to serve in custody, credit for time served since January 19th, 2024, after which then this case is closed. So
it means I have to do about 25 more days.
you do the math.
You're going to get credit for the time you've already served.
I'm just trying to get understanding on what it is that the judge is saying. I'm not trying to, disagree with anything it is, because she's right. I haven't done anything. My apologies. I'm not trying to make that go anywhere. I'm just trying to follow the procedure is all I'm trying to do, Your Honor.
All right, I thank you for the apology. And yes, you will be given credit for the time that you've already been in jail since January 19th. So today is the 16th. So I'm thinking you've already done about 25 or 26 days. So that will be deducted from the 59 days. And then the sheriff will do their own math and release you either from, then you do the math. I'm so sorry. I'm so sorry. 59 days minus 26 days, that leaves you with 33 more days. So that you would be given credit. You have 33 more days, which according to the sheriff's calculation will either be 15 or 16 more actual days in jail.
Okay, around about 2 or 3 more weeks.
Yes.
Okay, that's fine. Thank you, Your Honor. That's another chance that I probably don't even deserve, and I appreciate that, Your Honor.
It's okay, Miss. We don't talk. You're not fighting any of this, which is what I had stated to the court before. On his other case, Your Honor, he is prepared to accept the state's offer on that as well.
All right. Durante Smith on position 14 is 22 CR 005853E, accused of battery family violence from June 5th, 2022. Mr. Smith, you've been advised of your right to remain silent. Ms. McLeod is your counsel. Mr. Smith was brought back into custody pursuant to a bench warrant. And Ms. Kim, what was the recommendation? I don't think that was elocuted.
Yes, Your Honor, the state's recommendation, it's 12 months, serve 50 days, credit for time served 25 days, take a family violence intervention program, and no further contact with Keosha Lewis, and stay away from the incident location. Keosha Lewis is spelled Keosha, Lewis, common spelling. State would ask to sound for the victim at the end of this colloquy and ask the defense to stipulate to ID, venue, and factual basis for purposes of this plea.
We so stipulate.
All right. And Ms. Kim, I'm not sure. I don't know if the state had created a separate FTA case. Normally we do, but I haven't seen those. Ms. Falk?
Your Honor, to my knowledge, there was not a separate FTA done on this one.
Okay.
What I can do is get with the litigation manager, see if we can get one created, if one had not already been created, and then go ahead and do the null pros on the FTA.
All right. My only concern was that once he's done with his time in his probation revocation matter, and this one, there's nothing holding him back in the jail like an FTA that's not been resolved.
Understood, Your Honor. I'll work on that.
Thank you. All right. Mr. Smith, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide for purposes of this plea will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Smith, you can put your hand down. Have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes.
And is anybody forcing you or inducing you to take this plea offer today?
No one but myself.
All right. All right. I'm not sure how to take that, but you're entering this plea freely, willingly, and knowingly. Would that be correct?
Correct. My apologies. Yes, ma'am. No one's inducing me.
If you decide to enter a guilty plea to this charge of battery, family violence, that would go on your record. Therefore, any subsequent arrest for a same or similar offense will automatically be a felony charge. Are you still willing to move forward knowing this?
Yes, ma'am.
You would have to give up your constitutional right to a trial to challenge this charge in a court of law. You will not be able to confront your accuser. You will not be able to challenge the evidence brought against you. You will not be able to have the assistance of counsel to present any defenses or mitigating factors. And you will have to give up your right to have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up this right?
Yes, ma'am.
How do you plead to one count of battery, family violence?
Guilty.
Your sentence is 12 months to serve 50 days, credit for time served 25 days. Your jail time for this new case is completed. Once you are released from your revocation matter, you will then report to the probation office, which is located at 132 Mitchell Street in downtown Atlanta. You will report on the first business day immediately after your release, which will be a Monday, a Tuesday, or a Thursday, but you must report before 3 p.m. While you're on probation, you will complete a domestic violence intervention program, and you will also have no contact with Keosha Lewis. And I do apologize, I forgot to call out for Miss Lewis. Keosha Lewis? Keosha Lewis? If you're present, please unmute and start your video. All right.
Your Honor, I would just like the court to know that they share a 4-year-old that he currently sees to a third party.
All right. Mr. Smith, so as I was saying, you're to stay 200 yards away from Miss Keosha Lewis. You're not to contact her in any way, form, or manner, including in person, through a third party, through a phone, email, through mail, or even on social media. In order for you to resume your parenting plans with the child that you share with Keosha Lewis, you'll be required to file a legitimation action in the appropriate superior court. Your contact with your child will then be established by a superior court order. Do you understand?
Yes, ma'am.
All right. So you cannot continue with a third-party parenting. You must go through superior court and get a court order in order to establish paternity, visitation, and joint custody. Any questions?
No.
All right. I want you to start doing everything the legal way. So hopefully this will be a start. Thank you.
Thank you.
Thank you, Your Honor.
All right. Ms. McLeod, you have another probation.
I do, Your Honor.
All right. And do you need to speak to that person once they're available?
Yes, Your Honor, I do need to speak.
Thank you. All right. Judge, iPhone, do we have another case?
Yes, but not on this floor. I have to go to another floor.
All right, sir. I'll see you shortly. Thank you.
Sorry to interrupt, Judge. Ms. McLeod, I do think your client is here, DeMontre Kendall.
Yes.
He's here in the courtroom, so we could set you up on my laptop.
Perfect. Thank you.
All right. So you'll need to speak with him, Ms. McLeod?
I do, Your Honor.
All right. Thank you. Then in that case, Miss Vigilante or Mr. McLean?
Yes, Judge, I have 4 people I'm ready with. Do you have something?
No, I have the need to talk to some clients. It looks like they're not in the courtroom, so if I can get on the phone or a breakout session with them, then I'll be able to prepare their cases.
They're not in the courtroom, you say?
The people who are here in the courtroom are for the 11 o'clock.
I see.
Is that correct?
No, these are all mine.
Oh, I'm sorry, I was mistaken. I asked each one their last name. I don't have anybody on my list that's in the courtroom. I'll put it that way. Sorry.
All right, as soon as they're available from the different jail locations, we'll definitely place you in a breakout. Ms.
Super.
Vigiletti, if you'd like to call your first case,
Yes, Judge.
or Deputy Norris, whoever doing the calling.
We do probation first. I have 3 people on the probation calendar, so we're gonna go there first.
All right.
We're gonna go to position 8 on the probation calendar, Moore Willie.
Judge, this is Willie Moore, who I did send you a significant number of emails about.
I'm sorry, Ms. Vigiletti, one of the judges is trying to reach me. What was your announcement just now?
Oh, I just said this is Willie Moore, who I did email you about last night. And then
Yes.
I just forwarded an attestation from the director of the program, Mr. Moore, has been in, that he completed 1,100 hours of community service in the past year.
All right. Yes, I've had an opportunity to review your documents, but we will proceed with the revocation hearing and see where we go from there.
Sounds
This
good.
is Willie Moore on the probation revocation calendar, position number 8. Mr. Willie Moore, case number is 17 CR 019-494C. He was originally charged with a DUI, and I'm going to let Officer Allison advise me as to his conviction and the recommendation for the alleged probation violations. Mr. Moore, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Officer Allison?
Okay, he has failed to pay court fines and surcharges in a total of $1,411.50. Probation supervision fees in a total of $48. Did not complete drug and alcohol evaluation, did not complete risk reduction course, and failed to appear to a hearing on February 27th, 2019. He was to complete 70 hours of community service, which was to go towards his court fine. He has 189 days remaining. Probation is recommending to revoke the balance.
All right. And based on the information you sent to the court, did you also share that with Officer Allison, Ms. Vigiletti?
I did, Judge.
All right.
I'm sorry, I have not gotten a chance to open those attachments right now. I will right now, though.
I could summarize what.
Go ahead. I believe you said he's completed, what was it, 100 hours of community service?
1,100 hours of community service in the past year. He's spent the past 11 months in rescue mission in Macon. It's a residential rehabilitation program. Mr. Moore on Mondays, Tuesdays, and Thursdays participates in recovery meetings. On Wednesdays, Fridays, and the weekends, he goes to chapel, and Monday through Friday, he takes behavioral therapy classes as part of this program. So I know one of the terms of his probation was not completing the alcohol and drug evaluation and treatment. But I did provide his story of recovery as well as his certificate of completion of that program. Let's see.
I don't know what stage Officer Allison is at right now, but I do see the letter from Rescue Mission. And his certificate of completion of the community service hours, though I can be very forthright and said I've never seen one completed for those many hours.
Yes.
Any
for community service, which one was that one?
I just forwarded you a second email from the director of the program, who just this morning sent over an attestation of the number of hours Mr. Moore has completed.
It's from Rescue Mission.
Yes, that is
Oh, I
one of
got
the
it.
directives.
It's not a certificate, it's a letter, it's a recitation from the director.
Okay.
So Judge, Mr. Moore, acknowledges he did not do what he was supposed to do on probation in 2018 and 2019. But he did celebrate his 1-year sobriety anniversary this past Tuesday. He did voluntarily turn himself in on this issue in order to get this resolved and move forward. He has moved to the portion of the program where he lives in transitional housing and seeks employment. We had a long talk yesterday on what's changed for him, and Mr. Moore just told me that, he was tired of being a person he wasn't proud of. And I think that you can see reflected in the community service and the rigorous programs he's done in the past year that this is the type of person who has already done the work that we want people to do when they're on probation. So we're asking the court to grant time served today, and in the alternative, to perhaps give Mr. Moore an opportunity on probation to do just that final risk reduction class, which is the piece that he hasn't completed in the past year.
Understood. Officer Allison, anything else to add?
No, not at this time.
All right. Mr. Moore, I don't know if you and I ever encountered each other, but I can be quite frank that I'm not a person who takes DUI very easily. I'm very strict with regards to enforcement of sentences. I do appreciate the time that you have committed to the military, and we truly do thank you for your time. But then things do not go one's way, as apparently things have not gone well for you in the past. But I applaud you for taking the direction and the effort to correct these problems that you've encountered in the recent past. But one thing I will be very emphatic about, and I do frown upon, is that you have decided to disregard the sentence that was imposed upon you for your DUI conviction, and you decided to do it your way. All right? Even though I do applaud you for taking the steps and going in the right direction, that does not mitigate the fact that you disregarded a court order. And I don't appreciate that. You don't get to dictate your own sentence. You are convicted of DUI, a very dangerous offense in our society. You do not get to tell the court how you want to carry out your own sentence. Do you understand?
Yes, ma'am.
I am going to mark this down as a probation violation, but I am going to revoke the balance and commute that to time served. This matter is now closed.
Thank you, Judge.
Recording in progress.
I got 2 more probation folks, Rafael Diaz and Tyrone. I have 2 more on the probation calendar.
All right, Ms. Vigiletti or Officer Norris, the next case, please.
Position number 3 on the probation calendar, Rafael Diaz.
Rafael Diaz is convicted of battery and case 18 CR 003-585Y. Mr. Diaz, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Officer Allison, you've been already sworn. What was he convicted of? And was it battery?
It was battery.
All right, and what's the basis for the revocation?
He failed to report as directed on April 7, 2023, April 7, 2023, April 27, 2023, and May 16, 2023, failed to complete anger management. He has 77 days remaining on probation. Probation is recommended to continue on probation and enroll in anger management within 30 days.
All right. Ms. Vigiletti, does your client want to accept the recommendation?
Yes, Judge, and I will just add, Mr. Diaz did did complete the anger management course. He is telling me he gave it to one probation officer and then was sent to a different probation officer. So we're thinking the proof got lost, but he still has that proof. So he can bring that right to the office as soon as he's released, and that's not a problem. But that is why he stopped reporting, because he was told once he completed that class, he could stop reporting. So he didn't intend to be a no-show to probation. So
Let me check with probation. Miss Officer Allison, was his probation terminated on non-reporting upon completion of anger management classes?
I can check right now, Judge. He goes non-reporting after everything is completed.
Any proof of submission of a anger management certificate?
No, not at this time.
All right.
He does still have that, so he's happy to bring that to the office, and we'll just continue on this way.
All right. I'm going to mark this as a violation unless you have something else to add.
I don't, Judge, I don't have the proof here. I would be happy to present it to you, but I just met Mr. Diaz this morning.
All right. I'm going to mark this as a probation violation. He's going to be given credit for the time served on the remainder of the 77 days. He reports to probation on Monday at 132 Mitchell Street in downtown Atlanta. And he will continue to report until he provides proof to the probation officer that he completed his anger management. If he does not have the necessary certificate, he must enroll in the anger management classes to complete the classes within 30 days of being released. However, if he does have the proof that he's completed all anger management classes, he must receive information from his probation officer in writing that he has completed this condition, that he has completed his payment of probation fees and so forth, and then get it in writing that his probation may then be maybe non-reporting henceforth.
Okay, thank you, Judge.
So he's going to continue on probation, enroll within 30 days, and credit for time served.
Next, we have position number 1 on the probation calendar.
Sorry, Your Honor. Does anyone know when Rafael Diaz was arrested?
It was January 25th, 2024.
Okay, thank you.
All right. Miss Vigiletti, is your laptop in a, I see it still here with Miss McLeod. I didn't know whether they were supposed to be in a breakout.
No.
They were.
Sure, we were, but it's over.
Okay, just want to be sure. Thank you. All right, Miss Vigiletti, this is, I'm sorry, this was position 1 on the probation.
On the probation calendar, yes.
Yeah.
Tyrone Boykin.
Thank you. Tyrone Boykin is case 22 CR 6832E, in which he was convicted of battery. He was recently arrested on a probation warrant count. From arrest date is January 25th, 2024. Mr. Boykin, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. This is a revocation matter with regards to the sentence imposed on the battery conviction. Officer Allison?
Mr. Boykin failed to pay probation supervision fees in total $240, victim crime funds in total $54, failed to report as directed on February 24, 2023, March 17, 2023, and April 13, 2023, failed to complete anger management program, and failed to provide proper samples of court-ordered drug and alcohol testing. He has 150 days remaining on this case. Probation is recommended to continue on probation and enroll in anger management within 30 days.
Was it enroll in anger management?
Yes, enroll in anger management within 30 days.
Okay, thank you. Ms. Vigiletti?
Yes, Judge, I just spoke with, I'm sorry.
I'm sorry.
Thank you. I just spoke with, I'm sorry, I was hearing myself through Mr. McLean's phone and it was driving me nuts, but
Hey, you said it, not me. Okay.
I spoke with Mr. Boykin this morning. he takes full responsibility for not completing the terms of his probation. He lives far away from the probation office, was having some trouble getting there. He is working now. He manufactures car parts, and he just got a car for himself. So he's very grateful to accept the recommendation, and will be sure to complete these terms in the next 5 months.
How far is far?
I'm sorry, can you remind me?
Harrison, Georgia.
Harrington, Georgia.
Must be far, never heard of it. Okay, thank
Yeah.
you. All right. Mr. Boykin, I will record this as a probation violation. You'll be given credit for the time served since January 25th, 2024. You will continue on probation to complete the remainder of your 150 days. You will report to probation on Monday before 3 p.m. at 132 Mitchell Street. After that, you need to show proof to probation that you have enrolled in the anger management classes within 30 days from today. As you are now mobile with a car, you are required to report every month until the rest of your 150 days are over and that you have completed the anger management classes. Any questions?
No, ma'am.
Thank you, Judge.
Officer Norris, any other cases to be addressed in the courtroom?
Yeah, Quentin Welch. I don't know what position.
Position 17, yep.
On the state offer.
And Ms. Vigiletti, how are we proceeding on this one?
Judge, I'd like to discuss the possibility of a non-negotiated plea.
All right. This is State versus Quentin Welch. He's got 1, 2, 3 cases with us. 24 CR 005, 000504Y, accused of reckless conduct and discharging of a firearm on or near a public highway or street from September 27, 2023. Second case is 24 CR 505Y, charged with simple battery family violence from October 30th, 2023. Third case is from January 25th, 2024, and this is 24 CR 506Y, and it's 2 counts of willful obstruction of an officer and failure to use a crosswalk. Mr. Welch, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. This is going to be a non-negotiated plea hearing in which the state is going to indicate what's the recommendation, and then after that, I will hear from your counsel. I'll make a decision as to which recommendation I will accept and let you know, and then you can decide whether you want to move forward with the plea or whether you would like to enter a not guilty and have the case further notice for trial. Ms. Falk?
Yes, Your Honor. I'm actually having trouble retrieving the warrant information for this. So if I could ask for just a 5-minute delay so that I can get the, so I can try to get that information and I can read the facts into the record.
All right, we are going to take a pause on Mr. Welch's case for a few minutes. Ms. McLeod, are you ready to address your case? And your
Yes.
client's name, please?
I'm sorry?
Your client's name, please?
Yes, it's Deron C.L. Smith.
Smith, on the probation calendar, if I'm not mistaken. DeMontre Kendall?
Yeah, I'm sorry, Demontre Kendall. The previous one was Mr. Smith. I'm sorry, Your Honor, Demontre Kendall. Both of them have the same first name. Yes, Mr. Kendall, Your Honor.
All right.
We're swapping.
This is DeMontre Kendall, case number 21 CR 002680J. Mr. Kendall was convicted of carrying a concealed weapon and was placed on probation. A probation warrant was issued. Mr. Kendall, you have a right to remain silent as so advised, and your attorney is Ms. Maureen McLeod. This is a probation revocation matter. Officer Allison, what was he convicted of?
The offense was carrying concealed weapon, for probation, purpose of probation hearing. He has failed to pay probation supervision fees in total of $40, victim crime funds in a total of $9, failed to report as directed on July 6, 2023, July 11, 2023, and July 27, 2023, and failed to obtain a GED. He has 203 days remaining on this case. Probation is recommended to continue on probation and show proof of the GED or progress towards the GED within 30 days.
Don't we do GED classes at the jail? I think we
I
do.
do not. I'm
They
not sure.
used to have GED classes at the jail. I'm not sure if they still do.
Okay. Miss Vigilante? Oh, sorry, Miss McLeod?
It's me, Your Honor.
Yes.
Yes, my client was having some difficulty, he tells me, at the time because he did not have a cell phone and probation was communicating with him through his mom. And that was the biggest problem because he was not getting the information, and that is why he was not reporting. He tells me that he is having a bit of a challenge with housing right now, Your Honor, but he does want to be reinstated on probation so that he can complete his GED and complete the other terms of his probation.
So he was having problems with his mother's situation. So I gather he's not living with his mother then.
That is correct, Your Honor.
And he has having problem with housing. He is what, 22 years old now?
Yes, Your Honor.
21. So he was under 21 when he was convicted of carrying a concealed weapon.
Yes, Your Honor.
And he has not done anything to get his GED since his conviction date.
Well, he was working. He tells me that he has been working on it, Your Honor. He doesn't have it yet.
And has he been employed?
He's looking for a job, Your Honor, and that was
He's
one.
not been working. He's not living with his mother, and he's not done anything for his GED. I'm
Well, he
sorry,
hasn't
McLeod.
been-
Why am I letting this poor child out released back into the community if we can stay at the jail and work towards his GED?
It sounds like they are not offering the GED at the jail.
I'm
anyway.
sure we can make efforts to help him. Mr. Kendall, you have 203 days left. I mean, if I give you credit for time served, that's about 100 more days at the jail. You would have housing and an opportunity to get your GED done. Because you did not report to probation when you were required to do so when you're convicted of a firearm charge. I'm sorry, folks. Yeah, I'm just struggling to find a reason to release this young man back into the community. Ms. McLeod?
You know we don't know how long the GED takes. Perhaps it might be a good idea for him to get it done if we know for sure that he's going to get it done in jail. But 100 days is still a long time.
I don't know. He may be stuck in jail for 100 days just to finish out his sentence for this case. Because right now, as you said, he doesn't have housing. He doesn't have any incentive to go and do his GED. I'm still struggling to find why I should release him back into the community.
I understand the court's position, Your Honor. I am just wondering if he will be able to get this GED done in jail, because I think having a GED would help him in terms of getting a job when he goes back out.
Right. Mr. Kendall, I'm still not convinced that you are someone who's going to comply with probation. That's entirely up to you. You're over 21 years old. You're supposed to be considered an adult now. So I'm going to treat you like an adult. This is going to be recorded as a probation violation. I'm going to give you credit for the time that you've been in custody. You have you still have about 200 more days left to serve on your sentence. You will report to probation on Monday. Today is Thursday, in case you're wondering, but next Monday you will report to probation before 3 p.m. You will continue on probation and you will report twice a month. Within 30 days of being released, you will show that you have enrolled in a GED program. And you can either do that through the Salvation Army, you can do that through some nonprofit agencies, but it's up to you to decide how and where you're going to get your GED, because I am treating you like an adult. And you are expected to act like an adult and find out where you need to enroll and complete your GED. Do you understand?
Yes, ma'am.
If you do not report to probation twice a month, if you do not show proof of enrollment in a GED program within 30 days, then probation is authorized to issue another warrant for you to come back to jail and serve out the rest of your sentence.
Your Honor, would the court consider waiving some of those fees for him because he's not working?
I will waive his probation fees up to and through the end of April 2024.
Thank you, Your Honor.
But he is over 21. He appears to be healthy, and I don't see any reason why he can't find a job and eventually get back on his feet to find housing.
Thank you, Your Honor.
All right. Mr. Kendall, as I said, I don't have any problem keeping you at the jail. So you can either decide to finish out the rest of your 200 days at the Fulton County Jail, or you can accept this opportunity to get back on probation. What would you like to do?
I would like to accept the recommendation.
All right. Remember, she said that. See you, make sure you are seen by probation on Monday before 3 p.m. Thank you.
Can I ask, like, what's the address?
132 Mitchell Street in downtown Atlanta.
Okay.
It's
Thank
not
you.
123, it's 132. Okay?
Thank you, Your Honor.
Good luck.
Thank you, Your Honor.
Your Honor, the state is ready on Welch now. I was able to pull up that information.
All right, going back to our SAP calendar. Ms. Vigiletti, if your client, Mr. Quentin Welch, will see him. All right, yes, Ms. Falk, position 17, 18, 19 on the SAP calendar.
Yes, Your Honor. I'm going to start with the facts on position. Let's see. I'm just toggling back and forth between calendars, Your Honor. I am going to begin with the facts on position 17, which was the reckless conduct and discharge of firearms on a roadway. On that case, which happened September 27th of 2023, the incident happened at 651 University Avenue, Southwest, Apartment 5 in Atlanta. Officers responded to that location regarding a incident that happened between the defendant and his brother, Cedric White. Video from across the street showed that the defendant walked away after firing a single gunshot following a disagreement with his brother. The shot was fired on the sidewalk adjacent to 651 University Avenue Southwest. At the time of this incident, the defendant was 18 years of age. The second case, which happened January 25th of 2024, which is the failure to use crosswalk and willful obstruction. On that date, January 25th, 2024 at 651 University Avenue, officers were conducting a routine patrol in that area after receiving complaints from the community about an increase of narcotics activity. They observed the defendant walking out of the complex, attempting to hide his face. He walked into the middle of the roadway to cross the street, failing to use the crosswalk. He was actively looking in the opposite direction. Officers then pulled in the gas station in which he walked into, gave him lawful commands to stop. At that time, he began running away from the officers and ran into the street in heavy traffic. After a lengthy pursuit, they were able to detain him. He had active warrants for reckless conduct, discharge of a firearm, and the simple battery family violence that I'm about to go into. Lastly, we have the simple battery family violence case. That incident happened October 30th of 2023. In that case, officers responded to Mr. Daryl Welch, who's the father of the defendant. He stated that he was assaulted by the defendant, his son. He stated he was punched in the face following a verbal disagreement. This was witnessed by 52-year-old Patricia Welch. And at that time, the defendant fled the scene before the officers arrived. We did have an opportunity to speak with Mr. Daryl Welch, the father of the defendant. He confirmed the events in the warrant. He stated that the incident location is the defendant's residence. He was there to just pick up his stepdaughter's children. He said this isn't the first time he's had altercations with the defendant. He stated the defendant continuously threatens to shoot him, and he stated that he wants no contact with the defendant and for him to stay away from his residence at Meadowwood Square. The state's recommendation, what we're seeing is, and this defendant only has the one arrest, but we're seeing a very troubling history with 3 incidents in a period of over several months, where the defendant not only has threatened to use firearms against individuals, but has actually used a firearm in an altercation with an individual, his brother. For that reason, the state's recommendation on position 17 is 12 months, serve 180 days. He will receive credit for time served from January 25th of 2024, which would be approximately, excuse me, Your Honor, just a moment, which would be 22 days at this point, credit for time served. No further contact with Cedric White, no firearms. We are also on position 2, the discharge of firearms on a public street, asking for 12 months to run consecutive with count 1. So that's going to be a 24-month sentence with 180 days to serve. Credit for time served, 22 days. From January 25th, 2024, no further contact with Cedric White and no firearms. On case number 18, the simple battery family violence, state is requesting 12 months probation, family violence intervention program, no further contact with Daryl Welch. We are asking for a stay away, and I will put the address of the stay away into the chat for the litigation manager. 40 hours of community service, no firearms, and that would run concurrent with position 17. And finally, on position 19, failure to use a crosswalk, willful obstruction of an officer. The state will be no crossing count 1. We are going to ask for 12 months probation on counts 2 and 3. That is to run concurrent with the position 18. So the total would be that 24 months with 180 days to serve. Family violence intervention program, 40 hours of community service, no firearms, and a stay away from Mr. Daryl Welch. Let's see.
And Cedric White.
Yes, Your Honor. And we would like to sound for Mr. Daryl Welch and Cedric White if they are here.
All right. Mr. Welch and Mr. White, if you're on the Zoom, you need to unmute and start your video. All right. Ms. Vigiletti?
Yes, Judge. I guess first I would just like to state for the record that I've asked for documents related to Mr. Welch multiple times and have not received that. So I'm hearing these facts for the first time along with you. For that reason, I will not speak to the facts today. The reason we wanted to discuss the possibility of a non-negotiated plea is because Mr. Welch was offered a plea recommendation last week on the SAP calendar, February 8th. That is quite different from the plea offer today. And the only reason he didn't take that offer is because we didn't have any documents related to the facts. So he didn't even know what he was being charged with or why. He had sort of no idea.
If you need more information about the case, we can reset it 2 weeks out. I mean, the recommendation is 180 days. Or we can arraign the case and further notice for trial where the state will be required to provide discovery?
Yes, Judge. If you're not agreeable to consider the recommendation that was made last week, In Mr. Welch's case, then he would like to plead not guilty today.
All right. Will you be filing a waiver of arraignment or shall I accuse him?
Mr.
Excuse me,
Welch-
arraign him.
Mr. Welch is 18. This is his first time ever being in trouble, so I think it would be good to arraign him, Judge.
Okay. And do you waive a reading of the accusation?
Yes.
All right. So, Mr. Quentin Welch, you have 3 separate misdemeanor cases at the Fulton County State Court, stemming from 2 incidences in 2023 and 1 incident in January 2024. The first case number 24 CR 0504Y was for reckless conduct and discharging of a firearm on or near a public highway or street from September 27, 2023. Warrants were issued for your arrest stemming from that incident. On October 30th, 2023, a warrant was issued against you for simple battery family violence involving Daryl Welch. Subsequent to that, on January 25th, 2024, warrants were issued against you for 2 counts of willful obstruction of a law enforcement officer and failure to use crosswalk, stemming from a January 25th, 2024 incident. With regards to all these 3 cases, you have a total of 3, 4, 5, 6 misdemeanor offenses. You are legally presumed innocent in the eyes of the law. And when this case goes to trial, upon your entry of not guilty, the prosecutor, which is the Solicitor General's Office of Fulton County, would then be present, and they have the complete burden to prove beyond a reasonable doubt with respect to all 6 misdemeanor charges in order to obtain a conviction. If the prosecution does prevail and carry its burden to prove all 6 charges beyond a reasonable doubt, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. With the exception of failure to use a crosswalk, that would be subject to a fine of up to $100 and a sentence of up to 6 months. These sentences could be carried out separately or they could be carried out together. Given this information, how do you plead to these 3 cases and the 6 charges?
I'm sorry, Judge. We're just going to speak for 1 minute.
You are not on mute, Ms. Vigiletti? While we're waiting, jail court iPhone, who do we have there?
We have position number 2, Mr. Clark.
Okay. I think that's going to be Miss Vigiletti's client as well. All right. Are we ready? Ms. Vigilante? Are we ready?
Yes, I'm sorry. One more minute, Mr. Welch is a
If
high
he's
school.
thinking about it, I can move on to the next case and come back to him.
Sure.
I have position 2, Mr. Clark, on jail court iPhone waiting to address you.
Judge, position 17 through 19, Quentin Welch is ready.
All right, as I was saying, these are the upon your entry of a not guilty plea, the case will be scheduled for trial. The state would have to carry its burden to prove the charges against you beyond a reasonable doubt. If they prevail, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each offense, with the exception of the pedestrian crosswalk, which could be up to 6 months in jail or up to $100 fine. Given this information, how do you plead?
You have to tell us.
Guilty.
Repeat, please.
Guilty.
You're pleading guilty to the offenses?
Yes.
All right, Miss Vigilante, I gather he's pleading guilty and subjecting himself to the sentence. This is not going to be a negotiated plea then?
Yes, Judge. Okay, that's what you want to do? Okay, Mr. Welch would like to accept the plea as offered by the state.
Mr. Quentin Welch, you are charged with a crime in the state of Georgia. When you're charged with a crime, you're legally presumed innocent of the charge. And when the case goes to trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. You are currently in jail because you have a bond. If you cannot make the bond, then you would have to remain at the jail until your case goes to trial. Are you entering this plea just so that you could get out of jail?
Asking, are you entering the plea to get out of jail? Sometimes people take the plea to get out of trouble. So is that what you're doing? plea of intelligence?
No.
And why are you entering such a plea? I am not convinced that you are entering this plea freely, willingly, and knowingly. I have the nasty suspicion that you're doing so just to get out of jail. Because you don't want to stay in jail and you can't make bond. That's just my gut reaction.
Judge, this plea offer does carry with it 6 months of jail time.
Yes, and that's why I'm wondering whether he's doing it just to get out of jail soon.
No.
You understand the question? Because this is Mr. Welch's first time in any sort of criminal legal scenario, I suspect he's maybe not quite understanding the questions.
Okay.
Are you clear on what the judge is asking? Okay. I'm sorry, Judge, would you mind just asking one more time?
Are you entering a guilty plea because you are truly remorseful and you believe that you have committed these alleged crimes? Or are you doing so just to get out of jail sooner?
Because I did the crimes.
Okay. Mr. Quentin Welch, then in that case, Ms. Falk has already allocated, or Ms. Falk has already explained that what are the terms required, that you would have to be in custody for up to 6 months and that you will be on probation for up to 2 years. Is that your understanding?
Yes.
All right. Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID as allocated by the state for position 17, 18, and 19?
We do for the purposes of the plea.
All right. Mr. Welch, have you consumed any medicine or alcohol recently?
No.
All right. You can sit up straight, you can lower your mask, and then you can answer the question loudly and clearly. All right. Have you understood that you are charged with 6 misdemeanor offenses?
Yes.
And do you understand that by pleading guilty that they will be on your criminal history record?
Yes.
I'm looking this way because I see a bigger screen of your face on my other monitor. That's why I'm looking at you straight. Even though I seem to be looking sideways, I'm actually looking straight at your face just to make sure that you understand and that you're doing so freely, willingly, and knowingly. All right?
Yes.
Are you satisfied with your legal services, with Ms. Vigiletti's services as an attorney?
Yes.
Is anyone forcing you or inducing you to enter a guilty plea?
No.
And do you understand that if you enter a guilty plea, that these charges will go on your record and that you will have a criminal history record from this day onwards?
Yes.
Are you still willing to plead guilty to these charges?
Yes.
And are you willing to give up your constitutional right to go back to court and have a trial in front of a judge or a jury where you will have the opportunity to have an attorney assist you during the course of a trial? During the course of a trial, you will get a chance to confront your accuser. You will get a chance to use your attorney to challenge the evidence that's brought against you, to have your attorney assist you in presenting legal arguments and your defenses, if you choose to do so, and also get an opportunity for the prosecution to carry its burden and prove the charges against you beyond a reasonable doubt. These are all your constitutional rights, a right that you have as a citizen of this country. Are you willing to give up these rights and plead guilty to the charges brought against you today?
Yes.
How do you plead to 1 count of reckless conduct and 1 count of discharging a firearm at a public highway or street?
Guilty.
How do you plead to 1 count of simple battery, family violence against Darrell Welch?
Guilty.
And how do you plead to 2 counts of willful obstruction of a law enforcement officer?
Guilty.
On the discharge of a firearm, your sentence is 12 months to serve 180 days, credit for time served 22 days. The balance of the time will be on probation. At all times, you're to have no contact with Cedric White. You're to stay 200 yards away from Cedric White, and you cannot communicate with him in any way, form, or manner, including mail, email, phone, texting, or even on social media. Do you understand?
Yes.
On the charge of reckless conduct, it will be 12 months probation, consecutive to the probation with regards to the discharge of the firearm. Is that correct, Ms. Falk, or did I get it the other way around?
Your Honor, can you repeat that?
The reckless conduct will be 12 months probation consecutive to the probation on the discharge of the firearm.
The discharge of a firearm is consecutive to the reckless conduct.
Okay, so it's the other way around. Okay, Ms. Grace, I do apologize. The reckless conduct, the sentence is 12 months to serve 180 days, credit for time served 22 days, no contact with Cedric White, and no firearms, no alcohol, and no illegal drugs. Is that correct? Ms. Falk? Okay. And on the reckless conduct, the sentence is 12 months probation consecutive. That means, Mr. Welch, you'll be on probation for up to 2 years, less 180 days. Do you understand?
Yes.
As soon as you're done with your jail time, you will have to report to probation at 132 Mitchell Street in downtown Atlanta. If you fail to report after you completed your jail time, a probation warrant will be issued and you will be arrested and brought back to prison, where you will have to serve out the remainder of the 1.5 years left. Do you understand?
Yes.
On the simple battery family violence, your sentence is 12 months probation, and that is concurrent to position number 17. While you're on probation for that, you must finish a domestic violence intervention program classes, and the probation officer will advise you as to the qualified schools where you can get this classes done. You're also to have no contact with Darrell Welch and to do 40 hours of community service at any nonprofit agency. Do you understand?
Yes.
Your community service can be done at any nonprofit agency, which is not a church and not a school. If you have any questions, this is the time to ask. Do you have any questions?
No, ma'am.
All right. For position 19, the failure to use a crosswalk is null crossed. On the 2 counts of willful obstruction of a law enforcement officer, that's going to be 12 months probation to run concurrent to position 18. Ms. Vigilante, that's the sentence. That's the way I believe Ms. Falk had recited it. Do you find any corrections to be made?
No, Judge, that's my understanding as well.
Ms. Falk?
That is correct, Your Honor, and I did put the address in the chat to the litigation manager for the stay away.
All right. Ms. Grace, did we get the whole sentence down?
Yes, ma'am.
All right, thank you. That concludes these 3 cases. We are going to jail court iPhone. We have position 2, Marquand Clark. Ms. Vigilante, is that your client?
Yes, Judge, and I do need to speak with Mr. Clark briefly. We did talk yesterday, but I have an update from his other attorney.
Okay, if you'd like to use your handy dandy laptop, we can place you in a breakout.
Okay, sounds good. Thank you.
All right, Miss Jail Court iPhone.
Yes.
We need to place you in a breakout with Miss Vigilante. You will see a message on your screen to join a breakout.
Okay.
All right, thank you. Mr. McLean, do you have any cases in courtroom 2 which I can address? Or anywhere else?
Your Honor, we're just waiting on some clients to talk to through breakout.
All right.
Yesterday was the worst visitation this day I've ever seen.
I am so sorry.
I had not thought it could get but the worst before that.
I have a feeling you may be repeating that down the road.
It was terrible.
Okay, Deputy Norris, do we have a ETA from the other locations at the jail facility?
I do not, Your Honor, but I could try to find an
Okay.
ETA.
I'm going to take this time to go into my competency matter. And who will be going into the calendar with me? Miss Falk, Miss Abdon, Miss McLeod, Mr. Dennis Murphy, see here? Miss Kasha, PD social worker, anyone else? If you need to be in the breakout, please start your video. All right, Miss Krista Meadows, we will not place you in the breakout, so please close your video out. So All right. Courtroom 2. Yes, Ms. Vigiletti?
Yes, Judge,
Wow, you're all by yourself. What happened?
yeah, they've escorted folks out. Mr. McLean is still here. Jill.
I have jail court iPhone. Are we ready to address that case?
Yes, this is Marquand Clark. He's position 2 on the SAP calendar.
Okay. And how are we proceeding in this matter?
I've spoken with Mr. Clark and he would like to enter a not guilty plea today.
Okay. And are you filing a waiver of arraignment or would you like the case arraigned?
I can file a waiver.
Okay. Mr. Marquand Clark, case number 24 CR 459Y. Mr. Clark is accused of battery, family violence, battery against a female who's pregnant, and 3 counts of cruelty in the 3rd degree. This stems from a January 22nd, 2024 incident in Fulton County, Georgia. Mr. Clark, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Olivia Vigiletti is representing you. Mr. Clark, your attorney, Ms. Vigiletti, is going to file a document which we call a waiver of arraignment. Essentially means that you're pleading not guilty to the charges and that you would like the case scheduled for trial. Is that your understanding?
Yes.
All right. In that respect, this case is going to be further notice for trial, and you will get notice as well as the public defender's office of the jury trial scheduled in the division judge's office. Thank you. Jail court iPhone, you're free to go. Mr. Dennis Murphy, good morning.
Morning, Judge.
All right, sir. Are you ready to address the 2 cases you have on the 11 o'clock calendar?
I have 3, Judge. Yes, I would be ready to address them.
Okay, if you give us just a couple of moments, we already completed the competency calendar, but we'll come back to you. Okay?
All right, I'll stand by and I'll mute.
Thank you. Jail court iPhone, did you have another case? Jail court iPhone?
Yes, I do. I have to go down the hall. I have to get position number 1, Mr. Chastain.
Okay, could you give us about 5 minutes and then we'll be Mr. Chastain? Javaris?
Yes, he's down the hall. It'll take me about 5 minutes to go get to him.
His case is reset to February 29. That's Mr. Murphy's client. So we'll see next week.
Okay, then I have Mr. Thurman. He's an add-on number 2, Mr. Thurman.
Is that in 5 minutes time?
Yes, it'll take me about 5 minutes, yes.
Okay, then we'll be with you shortly in 5 minutes, okay?
Okay, all right, thank you.
Thank you. Miss Champion or Miss Grace, can you put me in a breakout with Kasha? Oh, is Kasha here, if she's still here? Miss Kasha? No? All right. It will just be Mr. Murphy, myself. Mr. Murphy, you're going to see a message on your screen, and Miss Falk.
I do see Kasha here. Yeah, I can join too.
Yeah, if she doesn't mind joining us in the breakout session. She may. Right. Miss Grace, should I just go back into the same breakout room?
Well.
All right, we are waiting for jail court iPhone. Miss Vigiletti, did you have? Is anyone in courtroom 2? Miss Krista Meadows, Miss Shelley Falk will reach out to you, or victim advocate will reach out to you. Miss Krista Meadows.
Miss Meadows, I have reached out to Miss Cheney to give you a call while I finish up the calendar, okay? But you can be excused. She will be reaching out to you.
All right, Miss Vigiletti, do you have, can you give me a status of your cases right now?
Yes, Judge, I don't have anyone else in the courtroom with me right now. I am told that they're having a hard time finding my clients. So positions 3, 4, 5, 3, 4, and 5 should have come to court today, and I don't know that they've been able to find them.
Okay, so let me do this then. Just go over the calendar. On the probation calendar, position 1, Boykin is continued on probation. Position 2, Amir Colkit Spivey.
I got confirmation this morning that he's been released.
Okay. Officer Allison, is that correct?
I was hoping he got released. We had put in a hold release about a week ago.
Okay.
We was hoping that he did get released.
Okay. Position 3 was continued on probation. That's Diaz. Position 4, McNeil commuted to time served. 5, Riles is I think it was continued on probation.
Riles was revoked.
Revoked, sorry. Riles was revoked. Position 6 was Deronta Smith. I believe that was also a revoke.
Yes.
Okay. Position 7, Ware was commuted to time served. 8.
Ware was continued.
Oh, I'm sorry. I really commute and continued, and my handwriting looked the same. Sorry about that. Continued on probation. Position 8 was time served. Is that correct?
Yes,
correct.
All right. Position 9, Terrence Wilburn.
He's a carryover from last week because we were told that he was released, but we weren't sure. They said he's not coming up in the system, so he must have been released. And so I think it was you and I had a short discussion of let's make sure of that. And so I did send an email to court records and haven't heard back yet. I need confirmation of whether he was released. I don't know, officer, if you know if he's been released.
I have no idea. It wouldn't be to us if he was.
Okay. I'm going to reset him to the probation calendar on February 22nd, pending release. So hopefully he's not at the jail. Okay, if he's not in jail on the 22nd, then it's just the case that we don't address.
Okay.
Position 10, Delmontre Kendall was continued on probation. Okay, so no cases from the probation calendar. Officer Allison, we're good to go. Thank you.
Thank
Judge,
you.
what
Have a
did you
good
say
day.
we're gonna do with position number 2?
Position number 2, that was he's been
released.
released. That's just further notice, but that's just that's done. He's
Okay.
released. There's nothing to
His
do.
case is closed.
Yeah, it's closed. Oh, all right. The SAP add-on calendar. Derek Clark.
Yes, Judge, he is a reset from Tuesday, and it's my understanding they have not been able to locate him.
Okay, so 1. Cortez Gibbs, have we addressed that?
Yes, that was a conflict case. I believe Ms. McLeod handled that one.
Your Honor, that was a plea.
Yeah, I see it. That was a plea, yeah. And that was 2 and 3. Position 4, Waylon Gibson.
Same announcement, Judge. He is a reset from Tuesday, and I have not yet been able to locate him.
Mikkel Godinez, position 5.
Yeah, for Mikkel, I'm a little surprised, you know, with Mr. Gibson, they're telling me they can't find him. With Mikkel, they're saying he's not coming up in any of their systems. So I'm just not sure what happened with him.
Let's okay, I'm just going to put a note over there, position 5. Position 6, David Tatum.
Waiting on him to appear.
Yes, so 6 through 10 are all Mr. McLean's clients, and it's the same announcement that we have not located them. Although I do believe Officer Gothi said he was on his way to position 7 and 8, Mr. Thurman.
He did say that.
Yeah. 7 and 8, we're going to get that. Position 9 is a reset to 229. That's Reginald Walls.
Okay.
Pending a felony transfer. So position 9's off the list, and 7 and 8 is on the way. Okay. All right, that's on our add-on calendar. So we are missing 1, 4, 5, 6, and 10.
Yes, good.
SAP main calendar. Position 1, Chesteng, is reset to February 29. Position 2, Clark, is further notice for trial. Position 3, David Eros Davis.
Has not been located yet.
Okay. Position 4, Michael English.
Has not been located yet.
Tariq Franklin.
Has not been located.
Nicholas Furtick.
Ms. Bach requested a DA transfer for Mr. Furtick because he does have prior family violence convictions.
And Your Honor, that DA transfer was granted by Edie Hutcherson, so I will be submitting an order.
All right. So position 6 is transferred to Superior Court. Thank you. Position 7, Zakia Johnson's reset to February 20th at 9 a.m. per Ms. Abden's request. Position 8, Ramisha McGregor.
Have not been able to locate.
Gary Nasser.
They believe there was a reset to 220 request from Ms. Bach.
Gary Nasser is reset to 220?
Yes, there is a second case, 24 CR 000112F, that needs to be added to this.
Right,
so that we can do a global recommendation.
All right, reset to February 20th. And could you put that second case number to Miss Grace so that she'll remember to add it on to the Tuesday calendar?
Will do.
Thank you. All right, so
He's going to.
Oh, yeah.
Daniel Oyevo, position 10.
We haven't located him yet.
Position 11, Jeremiah Philport.
Same issue.
I'm sorry?
Same issue. We haven't located.
Okay, same issue. 12, David Robinson.
We have not located Mr. Robinson.
Okay, Zakeith Sanders.
He is, according to another attorney in our office, Mr. Haddad, he spoke to him. He wants to be a negotiated plea. We think he's in Cobb County, so that may well be ready.
Today or another day?
Today, if they bring him, if they show him on Zoom.
Okay.
So I think the issue is that Cobb County is not present today.
Mr. McLean, is that your client, Zakeith Sanders?
Mr. Haddad is out. He will be mine today.
All right, position 13 is at Cobb. So if they don't appear, we have to reset it to next Thursday.
Right, we were
February 22nd.
Nothing is ever confirmed on location.
Okay, I'm just going to put a question mark and a hold on it right now. Position 14, Durante Smith is a plea. 15, Richard Tate.
Your Honor, we understand that that is Ms. Abbasi's case, private counsel.
Richard Tate is, and who's the defense counsel?
Leah Abbasi, A-B-A-S-S-I.
All right. Do you know if that's conflict or?
It may be private counsel hiring. We're not sure.
Okay, I'm going to reset this to 220 for Ms. Abbasi to appear. Position 15. Position 16, Desmond Thomas.
Waiting on the client to be shown to us by the jail.
Okay, 16. 17 and 18 and 19, Welch were please. 20, Kaylin West.
I learned late last night that Kaylin West is housed in Union City. I alerted the officers today and they said it was unlikely that they would be able to get Union City on Zoom today. So I think it will be reset.
Kaylin West is reset to 220. All right, and that was so on the main SAP calendar, we still have positions 3, 4, and 5, 8, 10, 11, 12. 13 is a possibility if he appears from Cobb, and 16.
Yes, Judge.
All right, waiting on position 7 and 8 on the jail court iPhone. So we'll be in a brief recess. Thank you.